We're here at the third aspect of government, the judiciary, the third arm of government. So the judiciary is the arm of government that's given the power to actually interpret the law and to resolve disputes between particular parties. Generally, the judicial power is exercised by the courts, and that's what we're going to deal with. Now, what we have to understand is that in the judiciary, in courts, there are hierarchies of courts, and we have different kinds of courts. So there are hierarchies within each of the 6 states and the territories. There's also a hierarchy within the federal sphere, the federal court, and a hierarchy around the family courts. And so basically there's a ranking of courts depending upon who can hear what. And so the higher up you are, the more serious the matter is. That's roughly the way that it actually works. So why do we actually have that hierarchy? Well, we have a hierarchy so that we have a way for appeals to work. So people, if they're not happy with the first decision, because it could be wrong, get a chance at a second decision. So we can allow probably the more experienced judges to hear the issues that are more important or that have a larger impact. And it allows the doctrine of precedent to operate, and we'll discuss that later. So what we find is that each jurisdiction or each level of government, like a state government or the federal government, each jurisdiction has its own court system, its own hierarchy that deals with the laws in place within that jurisdiction. There's often a criminal, there is a criminal and a civil jurisdiction within each of the states and federally, and each court has an original jurisdiction. What does that mean? That just means you can hear the case for the first time rather than an appeal. So you've got to have the case heard for the first time somewhere. That happens in the original jurisdiction, and that's different from the appellate jurisdiction, which is the ability of a court to rethink a decision of an earlier court, to review an appeal from an earlier decision. So particularly if you're outside the lower levels of the courts, up into the Supreme Court, etc., they have an original jurisdiction, so they hear some things for the first time, but they also have this appellate jurisdiction, which allows them to review decisions made by lower courts. We can see some key terminology in this slide here, which I'll let you look at. The parties we've been through before. In a civil case are the plaintiff and the defendant. In a criminal case, the Crown and the defendant. The burden of proof. Something we'll talk about a bit later, but the burden of proof is who has to be able to make their case. The burden of proof in a civil case is the plaintiff, the person bringing the action. In a criminal case, it's the Crown. The state must be able to show the proof necessary. The standard of proof required, civil case, balance of probabilities, what's more likely than not to have happened. In a criminal case, it's beyond reasonable doubt. Again, we'll come back to the standard of proof. Juries required, very occasionally in civil cases. They're not very common, but they are there sometimes. And in criminal cases, for indictable offences, there is a jury trial. What happens at the end? Well, in a civil case, the case is proved or not proved. In criminal, you're found guilty or not guilty. And the outcome from a civil case is a remedy, which is often damages, getting some money. Or in some cases, there are some other remedies in equity, a specific performance, which is making you do something, or an injunction, which makes you not do something. So there are these remedies that come out of a civil case. And in a criminal case, of course, we end up with that punishment. So let's look at this slide here and break it down a little about the federal court hierarchy. Okay, so the highest court, funnily enough, is called the High Court. It's the last court in Australia that you can appeal to. And so it has both an appellate jurisdiction, which is where it spends a fair bit of its time, to hearing appeals from federal courts and from state courts. Now, to hear that appeal, you have to be granted leave by the High Court. So that means they have to agree that they're going to hear it. You don't have this as of right appeal. So they have this appellate jurisdiction, and they also have an original jurisdiction. So there are some issues that the High Court of Australia hears for the first time. Issues around the Constitution are a classic to think about there. Very limited number of original jurisdictions. jurisdictions, a very limited original jurisdiction for the High Court. Now, we also have two other courts in operation in the federal court hierarchy. We have the Federal Court, which includes the original jurisdiction in the Federal Court of Australia, and then the full court of the Federal Court, which is the appellate jurisdiction. Why do they have that? Well, imagine that you had a decision in the Federal Court that one of the parties wasn't happy with. Well, then they need someone to appeal to. So generally you have more than one judge sit the second time and different judges, so you might have three, and they become the full court of the Federal Court. So you'd go original jurisdiction to the Federal Court, appeal to the full court of the Federal Court. If you still weren't happy, you could ask for leave from the High Court and appeal there. On the other side, you can see the same structure mimicked for the Family Court of Australia. So we have this possibility to get the original jurisdiction action, then an appeal to the full court, and then on to the High Court if they will grant you leave. So the High Court. The High Court is the highest court in Australia. It's the ultimate appeal avenue. So you can't appeal anywhere from the High Court. Well, actually, prior to the mid-80s, 1986, you could appeal from the High Court to the Privy Court, to the Privy Council, which was the highest court in England. But we no longer have that as an as-of-right appeal. So it is the ultimate level of appeal in Australia. It's made up of 6 justices and 1 Chief Justice. So there's 7 people who sit on the High Court of Australia, and they can hear appeals from any of the federal courts and any of the state and territory courts, and they can also hear some original jurisdiction matters that I went through before. In terms of original jurisdiction, we can see here that they can hear cases about constitutional issues mainly. When they're sitting in that original jurisdiction, you don't have all of the 7 judges. You usually only have 1 judge sitting there. And that way, when the appeal comes, right, they're not going to be involved in the appeal because you can't really sit in judgment on your own judgment. So the other people take over. So that's how the High Court from original jurisdiction actually works. In terms of the appellate jurisdiction, it can hear appeals from all of the state Supreme Courts, full court of the federal and family courts, but you need special permission, or what they call special leave, to appeal to the High Court. So with the Federal Court of Australia, what we find is we have an original jurisdiction about a limited number of matters. They deal with consumer protection, competition regulation, intellectual property, taxation and immigration. You can also then appeal from those areas to the full court of the Federal Court, where you'll have 3 judges sitting, and it will hear appeals from the Federal Court judge or a federal magistrate. So really you can see that most of the areas covered by the Federal Court come from those kind of heads of powers areas where the federal government has the ability to actually make the law. The Family Court of Australia was established in 1976 under the Family Law Act. It too has an original jurisdiction, quite a broad jurisdiction: divorce, custody of children, division of property, maintenance of the spouse, anything to do with family law. Again, they have an appellate jurisdiction, and that allows for appeals. There's 2 different kinds of appeals that can occur here. An appeal from a federal magistrate around family law issues can be heard by 1 judge of the full court. But if it's been to the Family Law Court as the original jurisdiction, it'll be the full court of the Family Court that actually hears that appeal. We can see here that the state hierarchies are somewhat more complex, more layered and tiered than what we find in the federal sphere. That's a reflection of the breadth of topics with which get dealt with at the state level. So we can see at the bottom there we've got Magistrates Court, which is our entry level. Above that we have the District Court, both the original and appellate jurisdiction. Then we have the Supreme Court, both an original jurisdiction, but also the Court of Appeal, or the full court of the Supreme Court, which can hear appeals. And we'll go through how this actually works. But what we can see here is that as you go up the chain in terms of the hierarchy, you can appeal to different courts. So if we look at the diagram, we can see that from the Magistrates Court, depending upon what it is, you can appeal to the District Court or to the Court of Appeal, the full court of the Supreme Court. If it's a District Court original jurisdiction, you can appeal to the appellate jurisdiction of the district court, and from there, from the appellate jurisdiction of the district court, you can appeal to the full court of the Supreme Court, and of course with all of that you can appeal to the High Court. If at first instance you're heard in the Supreme Court, that's the original jurisdiction, you can appeal to the full court of the Supreme Court, and then if you're given leave, to the High Court of Australia. So you're just following those arrows through to understand where you can appeal from. Generally, you're appealing from the original jurisdiction to the appellate jurisdiction and then to the higher level of court. So the Supreme Court of Queensland is the highest court that we have in Queensland. There's one Chief Justice and a number of justices who serve there. It's really got the ability to hear anything. It's got an unlimited jurisdiction, no upper level on what it can actually hear. In practice, though, it really only hears those very serious cases involving difficult points of law. The trial division, which is the original jurisdiction area, the trial division hears the most serious criminal cases, murder, manslaughter, serious drug stuff, and you get a jury in that case where the defendant can be found guilty or not guilty. The trial division also hears civil matters, so non-criminal matters, for things that are worth more than $750,000. So again, it's got to be a big dispute for it to go to the Supreme Court at the original jurisdiction. In civil cases, you're generally going to get a judge alone. Although sometimes you can get juries, but they're juries of 4. Just remember, most civil is judge alone, $750,000 for that Supreme Court. There's also the appellate jurisdiction that we find for the Supreme Court. It's called the Court of Appeal, the appellate jurisdiction, Court of Appeal, division of the Supreme Court, and it hears appeals from the Supreme and District Courts and a number of other tribunals. So there's 3 or 5 judges who sit on the Supreme Court, and they consider the appeal and make a judgment. Essentially, the Court of Appeal will either dismiss the appeal, which means they uphold the decision of the lower court, or it will allow the appeal, and then they set aside the decision of the lower court, so they overturn it. So juries. Now, you've probably watched a lot of TV where they have lots of murder trials with juries. So you're probably aware that it should be a group of ordinary citizens, 12 people, and juries are generally used for criminal matters. Prior to 2008, you needed a unanimous decision, but that's no longer the case in Queensland. For now, for trials, for anything other than murder, if the judge thinks that you're not going to get a unanimous decision after 8 hours, they can see if they can get a decision from 11 out of the 12 jurors. So that's Section 59A of the Jury Act. So you actually don't need unanimous juries in Queensland anymore under that section of the Act. There's also the ability to have judge-only trials for some crimes. Now, if you do that, you need to get an application, and the accused person needs to consent to it. You can see that it's quite complicated, and the factors that will be considered when they're looking at that application. So if you've got a very complex or lengthy trial, which would probably mean they're both, if there's a real possibility that someone might try and influence or retaliate against a juror, they might apply for that. If there's been significant pre-trial publicity, that means that you couldn't find a jury who wasn't tainted by understanding or having a view on what was going on. So there's a number of factors that get taken into account. It is possible then not to have a jury, although what you've got to balance that against is that the jury's there really to give a view on community standards around actions and what's required. So you're going to lose that if you don't have the jury. So you have these balance of factors about why you might not have a jury against the factors why you might do it. And a judge can come to a view if the accused person consents not to actually have a jury. Okay, so we move down the hierarchy. We now end up at the district court, where we have judges. Their original jurisdiction is for matters involving $150,000 to $750,000 and moderately serious criminal matters that come before it. You can get a jury in some criminal matters, and for a few civil claims, same procedures as for the Supreme Court. In terms of an appellate jurisdiction, the district court judge may hear an appeal from the decision of the Magistrates Court. So a magistrates can go to the district court. In the Magistrates Court, the people who make the decisions are called the magistrates. Their original jurisdiction is in criminally, they hear minor offences, shoplifting, traffic offences, and committal hearings. So when people are being committed to trial, they can hear civil matters where the amount is less than that $150,000. Remember, once you're over 150, you're in the district court. Once you're over 750, you're into the Supreme Court. What's a committal hearing? Committal hearing is where you have a serious or an indictable offence such as murder, and you've got to determine whether the prosecution will be able to make their case, whether the prosecution will be able to make its case. So it's really about deciding, is there a serious case to answer here? Could the accused be found guilty? Not would they, but could they be found guilty? So they're trying to get rid of the cases where it's highly unlikely, where really you couldn't find this person guilty based upon the evidence the prosecution has. So it's a preliminary step before it would go on to, say, the Supreme Court or maybe the District Court. If you do find that the person could be found guilty, then the accused will get sent to the higher court for a trial by a judge and jury. So here's another way to look at this court structure, and it's trying to put the three elements, the three different courts together. At the apex, we've got the High Court of Australia. The High Court federally also can hear things from the Federal Court of Australia, both in its original jurisdiction and the full court of the Federal Court. It can hear things from the Family Court of Australia, both the original jurisdiction and the appellate jurisdiction. Then we have the Supreme Court, which is a state-based. In our case, it'd be the Queensland Supreme Court, which has a Court of Appeal and a Court of Criminal Appeal, so that's the Courts of Appeal. And it also has the original jurisdiction as a Supreme Court, the Supreme Court original jurisdiction. Below that, we have our District Court, both the full court of the District Court and the original jurisdiction of the District Court, and we have our local Magistrates Court. We end up with this enormous tree or this enormous diagram of the hierarchy of the court system. The final group of bodies that we have to look at are tribunals. They're established by statute to regulate specific matters. They use tribunals to stop the court system getting clogged up, right? So that we've got too many cases going into the court system, we're going to have a separate way of deciding these specific areas of the law. Rather than have judges, often these tribunals have non-lawyers presiding over the tribunals, so there's a bit of a break there. We also see that the tribunals have a very limited ability to deal with the matters, so they're given very specific jurisdictions, which are usually outlined in the statute which created them. As a result, tribunals aren't courts, and they're not as formal as what courts are. As a result of how we've structured tribunals here in Australia, tribunals are quicker, cheaper, and easier for people who are involved. We're not going to look at a lot of the tribunals, but you should be aware of the Queensland Civil and Administrative Tribunal and the Commonwealth Administrative Appeals Tribunal. So, the QCAT, it reviews matters relating to residential tenancy, debt disputes, consumer and trader disputes. Disagreements for debts up to and including $25,000, so an unpaid invoice or accounted wages owing. So it's really trying to get a cheap, quick method of dealing with relatively smaller amounts of money. The Administrative Appeals Tribunal is actually a very big tribunal, a very important tribunal that began in 1976. Its aim is to review the decisions of the Commonwealth Government departments, including those of ministers. So it acts in judgment of the decisions of the executive arm of government, and we'll know that that's really important from our separation of powers. So it can only review a decision when the Act or regulation specifically allows it to. It's got the power to review decisions from over 400 acts and regulations to date, from areas like taxation, social security, immigration and citizenship. So we can see that tribunals have been set out as a different way of resolving difficult areas, and it's trying to get a cheaper, quicker way for those areas which have less money at stake and or which are specifically about the executive decisions of government. So a lot of material in there, but the court system and the hierarchy are really important to understand if we're going to understand precedent, which we're going to talk about next.